Hi, I'm Puneet Gupta, Tax Director EY India, and I will explain why a recent Supreme Court ruling on basic wages for calculation of PF contribution can lead to bonanza for employees, especially those earning basic salary below 15,000, and could be a financial burden for the employer. In its landmark ruling on 20th February 2019, Supreme Court has said that allowances which are paid by employer to its employees are covered under the definition of basic wages for calculation of PF contribution. So now PF contributions will be payable on basic wages and all allowances. Supreme Court have actually clarified that allowances of certain types are excluded from the definition of basic wages. So these are allowances which are either variable in nature, or allowances which are not paid to all across the board, or allowances which are linked to any incentive for production beyond a certain capacity, or allowances which are only paid to those who avail of a certain opportunity. For example, per diem, which is only paid to employees while they travel, are excluded. All other allowances can be included under the definition of basic wages. So this ruling will have a significant impact because mostly all employers today contribute towards PF only on basic wages, but now they may also have to include allowances in certain categories. There will be no impact for employees who are already earning basic salary more than 15,000. This is because under the PF scheme, employees, if they are earning more than 15,000 per month, they can restrict contributions on 15,000 rupees. So employees with basic already more than 15,000 rupees, this ruling may not have an impact for such category. However, for employees who earn basic salary less than 15,000, this ruling could have an impact because now employers will need to calculate PF on not just basic wages but also on allowances subject to a cap of 15,000 rupees. So I think we can better explain this impact through two scenarios. One is pre-September 2014 and one is post-September 2014. And remember, September 2014 is an important criteria because that is when the statutory ceiling under the PF Act increased from 6,500 to 15,000. So pre-September 14, the ruling will impact employees whose basic is less than 6,500 per month because now PF will be payable at least on 6,500 per month for such category of employees. Post-September 2014, the ruling will impact employees with basic below 15,000 rupees per month because now for such category PF will be payable at least on 15,000 rupees. So yes, it could have significant impact for both categories of employees. So this ruling will impact such employees because PF will be payable for them on basic salary and all allowances subject to a ceiling limit of 6,500 pre-September 14 and 15,000 post-September 14. For employees whose basic salary at the time of joining EPF scheme was less than 15,000 per month but is now more than 15,000, there will be impact only for the past, for the period when their PF contributions were made on less than 15,000 because now employers may have to pay contributions on allowances subject to the ceiling of 15,000 for past. For future, if their salary is already more than 15,000 and they're contributing on such higher salary, then there will be no impact. So for third category, for employees who at the time of joining PF scheme, the salary is more than 15,000 rupees, there will be no impact because they're already contributing on more than the ceiling limit. And remember, on 27th May 2014, EPF actually issued a clarification and directed its regional offices not to enforce employers to contribute beyond the ceiling limit. So there will be no impact for such category. The ruling may have retrospective impact. It will specifically impact employers for the period after September 2014 for employees with basic salary below 15,000 rupees per month. For the period prior to September 2014, it will only impact companies who have employees with basic salary below 6,500. On the question on how far authorities can go back, so the law is silent on this. The Supreme Court ruling having clarified this. There was a circular issued in the past by PF office saying that they can go back 7 years under a 7A proceeding, but that circular was taken back in a few days. So there is really no clarity on this from the authorities as yet. So if employer has to pay PF contributions for the past, then employer may be required to pay using employee's universal account number and their PF account number. So employers will have to pay even for employees who've changed jobs. So for the past, employers may have to pick up costs for past compliance. PF rules actually do not allow employer to recover past contribution from employee's salary. This means that employer will have to put in additional money to the PF accounts of employees, specifically those who earn basic salary less than 15,000 rupees or 6,500 rupees as applicable. Let's take an example. Say an employee whose basic salary was 11,000 rupees and allowances were 9,000 rupees, totaling to monthly salary of 20,000 rupees. Earlier PF contributions, if made by employer only on 11,000 rupees, employer will now have to put in additional money on at least and calculate PF at least on 15,000 rupees, which is the statutory ceiling, and this cost will have to be paid up by employer. This could mean that there can be a significant gain for employees and a huge financial burden for employer for the past.